date of birth, Mr. Gray?
Uh, Good afternoon, Your Honor. 72 is my date of birth. I have a
Can you say that again? Go ahead and say what you were about to say.
I have a motion before the court, Your Honor.
Let me first start. Do you need a lawyer, sir?
No, Your Honor.
City of Detroit versus Christopher Gray. State your name for the record, please.
Christopher Lamar Gray.
All right, today is the date and time set for a pretrial, and then there's warrants on the other matters. I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. And I'll recall the warrants. What is your motion, sir?
I have a motion to strike and dismiss.
What are the bases?
Basis of federal rules of civil procedure. Number one, there's no claim. There's no ratification of the claim.
There is a claim. There is a. Do you want me to read out I waived the reading of the information. You want me to read the allegations that have been made into the record? Do you need me to do that?
No, I don't. No, I don't, Your Honor.
I deny your motion on that basis. What else do you have to say? What else?
You deny my motion because.
Buckle up, guys. Today we're going to dive into a courtroom hearing that wastes absolutely no time getting interesting. The defendant confidently walks in with a motion to dismiss, believing he's uncovered a legal loophole that could end the case before it even begins. But the judge immediately notices that the motion is built on rules that don't even apply to a criminal case. Instead of getting frustrated, the judge calmly questions the argument, exposing its weaknesses one by one. What begins as a routine pretrial hearing instantly transforms into a fascinating legal showdown, leaving everyone wondering whether the defendant truly understands the law or is simply repeating legal phrases without knowing how they actually work.
You're saying, Your Honor, you're saying this is a criminal matter?
Yes.
Okay, well then we need the corpus delicti. And so that's what I'm asking for. If there was a criminal matter, basically what you're telling me is that something has happened, someone has either been damaged or someone has been or either someone has been damaged or someone has something has been come up missing. And if that's the case, then that means that there is a crime. And if there's a crime, then there is the what do you have that's saying that I did the crime? What you're saying that I created this crime that hurt this person. And if I hurt this person and I created the crime, then a third thing that you have to have is the identification of the person. You have the identification of the person, which is me, but you don't have a person saying that they were hurt or damaged, or the crime that's saying what I did to hurt or damage the person. So how do you have a crime?
Okay. You went to law school?
No, Your Honor, I have not.
All right, guys. Now the courtroom tension starts climbing as the defendant doubles down on his legal theory. He insists there can be no crime because no one was physically harmed, repeatedly bringing up the concept of corpus delicti as the foundation of his defense. The judge listens carefully before asking a simple but revealing question, whether he has ever attended law school. That single exchange changes the tone of the hearing, as it becomes clear the defendant has learned legal terms but may not fully understand their meaning. The judge then explains why criminal law doesn't work the way the defendant believes, turning this into a fascinating lesson on the difference between memorizing legal phrases and actually knowing how they're applied in court.
I've done some Cornell law studies. I've also sat down with a couple of friends who have had some issues. I picked up wherever I could, just started to study the law, just started to go back through Cornell law, started to figure out what was going on and to understand the nature of how crimes, what a crime is and everything else. So just a
And
course of me
Cornell
searching
law,
it out.
and you're citing Cornell law for all of that you just said to the court?
No, what I did, Your Honor, was I realized that one of the biggest portions that you have to have is you have to have the corpus delicti. And
Okay.
that is in when you're
What is a
being
corpus,
charged criminally.
what is a corpus delicti?
What do you mean, what is the corpus delicti?
What is your understanding of what corpus delicti is?
That is the corpus delicti is the law that's saying that there is a crime that's being committed. So in order to do that, you have to show the corpus delicti, which is you saying this is what happened. This is how this person was
Okay,
damaged.
so
There is no
the
person.
officer on this day, on these dates, because I got a lot of them, said
I
that you
object.
drove.
I object. The
Don't
officer
interrupt.
works.
Don't interrupt
Okay,
me.
I
Don't
apologize,
interrupt.
Your Honor. I apologize, Your Honor. My apologies.
Officer says that you drove a vehicle that wasn't registered and wasn't titled, or titled and or untitled, that you drove without a valid driver's license, that you drove without valid insurance. Again, on a different occasion, they allege that you drove without a valid driver's license and no insurance. And then on a different occasion, they allege that you drove without unregistered or untitled or both, and drove without a valid driver's license, repeat offender, that you failed to have a trailer plate, and that you failed to secure a load on your vehicle. And on another occasion, on the same occasion that you failed to secure, that they allege you failed to secure the load, failed to have a trailer plate on your vehicle, that you didn't provide a valid driver's license. So those are the crimes. And in state of Michigan, whether you agree or not, they are crimes. So based on your motion and all of that stuff you talked about, corpus delicti and things like that, the court denies the motion. Okay, based on those reasons I just said. Now, how do you want to move forward? Because wait a minute, I'm not finished.
My
How
apologies,
do
Your Honor.
you want to move forward? Because in my experience, someone that comes into court, as you do,
Yes, sir.
you do not want to take an offer. You do not believe that you need to have plates or registration or insurance, and you just disregard all of that portion of the law. And either you are going to move forward by having a trial, or you're going to take a deal. What do you want to do, sir?
Your Honor, first I want to
Buckle up, guys, because the discussion gets even more interesting from here. When the judge asks where this legal knowledge came from, the defendant confidently points to Cornell law and his own research, convinced that his interpretation is correct. Rather than dismissing him outright, the judge patiently walks through every charge listed against him, explaining exactly why the prosecution believes crimes were committed. One by one, the alleged violations are laid out, showing that the case isn't based on assumptions, but on specific statutes. By the end of this exchange, the motion to dismiss is officially denied, and it's becoming increasingly obvious that this courtroom battle is far from over.
You have two options: trial, or you want to take a deal.
Your Honor, I request a jury trial.
A jury trial.
A jury trial, yes, Your Honor.
Very good. Ms. Mathis, I need a jury trial date. Please.
And if I may, Your Honor, what time is Mr. Gray presently docketed?
I don't even think it matters, but I'll tell you. I don't think it matters. He's got the newer cases and the older cases are pre-trial at 8:35. Christopher Lamar Gray, and then he had some in warrant status. I counted 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases into the record. You know what I want to ask Mr. Gray, and you can choose to answer it or not.
Yes, Your Honor.
But what I surmise and what I've heard, and I don't know if you're alleging the same thing, is that and you basically did allege the same thing, that no crime has been committed because no person has been, you know, the people of the state of Michigan are in danger of you driving without the proper documentation or anything like that. But I don't, and I'm gonna surmise, and you can correct me if I'm wrong, that you're gonna say that there's no jurisdiction to be able to pull you over because no one has been injured. Is that correct?
I think that what I'm saying is that the city of Detroit had an officer pull me over to say that you're not following these rules. And my stance is, okay, well, then that's fine. If we're following rules, then therefore, let me make sure that you as well as are following the rules, because if I don't do that, then freedoms are lost. So that is in
Right.
which that is the way that I proceed to say, okay, well then if we're playing cards and we play and show me yours, if this is your hand, then this is mine, and let's proceed accordingly to the law. That's it. That's my only standing is if someone doesn't stand up every once in a while and define the edges, then they all disintegrate and people lose rights.
And you know something? With
Yes,
that
sir.
being said, I would agree with you 1,000%.
Mhm.
That's why I pride myself, and I hope I'm doing a good job for the citizens that come in here and the police for that matter and the prosecution, that I am calling the balls and strikes right. And if something doesn't proceed as it should, then I will dismiss the case one way or the other. But in my short time on this bench and in my time at practicing law as a defense attorney, I get this, you know, they can't pull me over. I've heard the corpus delicti, first time the civil procedure has been thrown at me. But from the way I see it, is that you just don't feel that the police have a jurisdiction to pull you over for these issues. Is that correct?
Do I have what again, Your Honor, what I feel is that if we are following rules, that if I have to follow the rules and every person out there, all of these officers, everybody else has to follow the rules. So if it comes
So what
down
I'm
to
gonna,
it,
so what I'm gonna hope that you do by
yes,
the
Your Honor.
time you come back on the trial date, this jury trial date is gonna be strike that, March the 18th, 2025.
Thank you, Your Honor.
You're probably gonna have an audience because everybody follows me on these cases all the time.
I understand.
All right, guys, with the motion now out of the way, the judge shifts the focus toward the next stage of the case. He presents the defendant with a straightforward choice: accept a deal or to take the matter to trial. Instead of choosing immediately, the defendant objects once again before ultimately demanding a jury trial. That decision instantly raises the stakes because now the case is heading toward a full courtroom showdown. The conversation then turns to jurisdiction, with the judge trying to understand whether the defendant believes the police had any legal authority to stop him in the first place. It's a pivotal moment that reveals the real philosophy driving his entire defense.
Trial date, final pre-trial. This is to you, Mr. Bowman, especially the day before on February 17th, 2025 at 8:30. So Mr. Gray and Mr. Bowman, Mr. Bowman, I need you to have all your officers appear on that date. Who's ever going to state these allegations, so that we know that we're not just summoning the people of the city of Detroit to a jury that's not actually going to go. So all parties must appear, and that can be via Zoom. And the trial is going to be in person. All right. All parties must appear on final pretrial date and obviously on the trial date. Um, and what I would implore you to do is you need to figure out the right game, because it doesn't sound like you're playing the right game.
I understand, Your Honor. I appreciate, first and foremost, let me say I appreciate the dialogue. I appreciate you sitting here and engaging with me at this level. So I recognize what you're saying, and so yeah, I guess it's to the table we go. So
Yeah, but get your game in order, because I'm just giving
yes,
you a
sir.
little heads up. If you come
Yes,
in with
sir.
that game on the jury trial date, then more than likely you'll lose, unless you can find one of those jurors or a couple of those jurors or even all of them to have some sympathy for you, sir. I don't
Well,
know.
I got a whole basis for understanding, and so yeah, if you know
Well,
it
that
is what it
basis
is.
that you outlined shortly today is not.
What was flawed in my what was flawed here?
Buckle up, guys, because this is where the hearing becomes more than just an argument over traffic charges. The defendant explains that, in his view, holding government officials accountable is essential to protecting everyone's freedoms, arguing that rules should apply equally to citizens and authorities alike. The judge acknowledges that principle and even agrees with the importance of accountability, but he also makes it clear that personal beliefs cannot replace established law inside a courtroom. As the discussion continues, the judge carefully separates constitutional principles from legal misconceptions before officially setting the jury trial and final pretrial dates. It's a respectful yet firm exchange that highlights the difference between questioning authority and presenting a legally sound defense.
We already discussed it. The federal rules of civil procedure that you brought up as a motion to dismiss, not the right basis. The corpus delicti, they do have a corpus delicti. They do have a crime that they say has been committed. And if you read the MCL, the Michigan court rules, and the Michigan statutes, then you'll see those crimes outlined there. They have them on the tickets. They got the statute numbers that are on the tickets. So that's not the right basis. So you're in a whole different ball game, and you need to come on to this ball game here.
Okay, all right, okay. Well, I guess we will have that discussion again. I appreciate it. I also want to say I recognize and honor your compassion that you sit on the bench with. I see it as you go out here and you judge our people, and so for all of that, kudos, man. That's for where you sit. I appreciate that. Thank you, sir. Appreciate it.
I appreciate
Yes,
that,
sir.
Mr. Gray.
Yes, sir.
You have a
Yes,
safe
sir.
happy holiday season, sir. And
You as well.
best of luck to you. I'll see you back on March the 17th, 2025 at 8:30 for a final pretrial. And let me say this, let me add to
Yes,
the record.
yes, Your Honor.
If there's any motions, those motions need to be in writing.
10 days, within 10 days.
Let's put that on the record to a motion. Those motions need to be in writing. Have those motions to the court by February 14th, 2025. And the response will be February 21st, 2025. And I'll rule on those motions on the final pretrial date of 3/17/2025. Again, all parties must appear, Mr. Baldwin, all right?
All right, guys, the hearing reaches its conclusion with one final reality check from the judge. Instead of mocking the defendant, he offers sincere advice, explaining that the legal strategy being used is fundamentally flawed and urging him to seek the help of a qualified attorney before facing a jury. The judge carefully explains why the motion failed, outlines the proper legal standards, and schedules the remaining court dates before ending the hearing on a respectful note. Whether you agree with the defendant's beliefs or the judge's reasoning, this exchange is a powerful reminder that confidence alone isn't enough. You also need a solid understanding of the law. If you enjoyed this breakdown, Don't forget to like the video, subscribe to the channel for more courtroom analysis, and we'll see you in the next video.